Okay, Judge Stein, we can get started.
Okay, good afternoon, everyone. I'm Leslie Stein. I'm the director of the Government Law Center here at Albany Law School, and I'm very pleased to welcome you to the third program of the 2024 Warren M. Anderson series. I also invite you to attend the final program of our series on May 7th on the powers of the governor in state budget in the state budget process, which I don't think could be any more timely. Just a few brief words before we begin today's program. I'd like to thank our series sponsor, George Weissman, in memory of Sharon P. O'Connor, Albany Law School class of 1979, and the other sponsor of today's program, Whiteman, Osterman, and Hanna, LLP. The mission of the Government Law Center is to help state and local governments better serve their communities through nonpartisan legal research and analysis by bringing together a diverse and inclusive group of lawyers, students, scholars, and community partners. We prepare students for careers as skilled and leading attorneys in public service, advance Albany Law School's unique connection to government, and inform nationwide conversations on government and the law. Today, we have an exceptionally distinguished and knowledgeable panel of speakers on the enormously important and timely topic of New York State redistricting. The moderator of the program is Richard Rifkin, the Government Law Center's legal director and an expert in this subject himself. Before becoming the legal director of the Government Law Center, Richard worked in New York State government for 40 years. He served as special counsel to former Governor Eliot Spitzer in various positions in the New York Attorney General's office and as executive director of the New York State Ethics Commission. He has written, taught, and presented on a variety of topics, including redistricting and government ethics. And before we turn to our panel, I want to remind everyone that a code word will be announced during the program, which will be necessary in order to obtain CLE credit. And with that, I will turn the program over to Richard, who will introduce our panelists.
Well, thank you, Judge Stein. Good afternoon, everyone. And we really have an outstanding panel this afternoon. All three panelists have been very active in the redistricting process over the last 2 years here in New York. What we're going to do today is divide the program into two. We'll spend the first part of the program reviewing legal developments that have taken place over the last decade or so. Jeff Weiss, our first speaker, will open the discussion and talk about national developments, focusing on the role of the federal courts and in their role in reviewing maps. Esmeralda Simmons, our second speaker, will then discuss developments in New York State over the last decade, focusing on the 2014 constitutional amendments, their implementation, or I think more accurately, their lack of implementation, and the Court of Appeals decisions that have followed these amendments. Excuse me. Following these legal analyses, Susan Lerner will offer thoughts for possible reforms in New York to avoid a repetition of the failures we have seen following the 2022 redistricting. The other panelists will then join in that discussion and offer their thoughts. So that's our program for this afternoon. And then, to the extent we have time, we will take questions from the audience, who can put them into the Q&A box, and they'll be followed here by Shel Miller. So with that, I turn the floor over to Jeff Weiss.
Yeah, well, thank you, Richard, and good afternoon, everybody. I'm going to take the next fast New York 10 minutes and give you an overview of major Supreme Court decisions in the redistricting field in the last decade, basically focusing on the Voting Rights Act and partisan gerrymandering. The first case I'll mention is Shelby County versus Holder, a case that changed the landscape of voting rights in the Deep South and a few other states, including New York. This landmark opinion dismantled the pre-clearance process of the 1965 Voting Rights Act, which had been in effect for almost half a century and prevented certain states and localities with a history of racially discriminatory voting practices from making changes to their voting process without federal pre-clearance. As a result of this decision, a critical accountability tool was literally erased in one fell swoop. In June of 2013, in this case, the court held that it is unconstitutional to use the coverage formula in Section 4B of the Voting Rights Act to determine which jurisdictions are subject to the pre-clearance requirements of Section 5 of the VRA. The court did not believe that a 1960s database formula was still relevant in 2013, and somehow the problems of the 1960s were no longer existent or present in the 2010s. The Supreme Court did not rule on the constitutionality of Section 5 itself, but the effect of the Shelby County decision is that the jurisdictions that were identified by the coverage formula no longer need to seek preclearance for the new voting changes unless they were covered by a separate new court order under Section 3 of the Voting Rights Act. We have not seen much action there in the last decade. The next case, Rucho versus Common Cause, dealt with partisan gerrymandering at the federal court level. And in that case, voters in North Carolina and Maryland challenged their state's congressional districting maps as unconstitutional partisan gerrymanders. The North Carolina plaintiffs claimed that the state's districting map discriminated against Democrats, whereas in Maryland, the plaintiffs there claimed that their state's plan discriminated against Republicans. The plaintiffs alleged violations of their First Amendment, Equal Protection Clause of the 14th Amendment, the Election Clause, and Article 1, Section 2 arguments. The district courts in both cases ruled in favor of the plaintiffs, and the state defendants in Maryland and North Carolina appealed directly to the U.S. Supreme Court, which then held that partisan gerrymandering claims present political questions beyond the reach of federal courts. This came down in June of 2019. The plaintiffs tried to make their case to the court by applying a three-part test. The first would be to examine the intent of the map makers, looking for a smoking gun, legislative record, what did they mean by passing this plan? The effects of the map, what would it do to the parties, to the voters? And then also the long-term results of the map, how did the map play out over a period of time? But the Supreme Court majority did not agree. Chief Justice Roberts, in his decision, held that the conclusion that partisan gerrymandering claims are not justiciable neither condones excessive partisan gerrymandering nor condemns complaints about districting to echo into a void. An interesting use of words, but the Chief Justice also basically said that gerrymandering itself is not unconstitutional, but that excessive gerrymandering is something that they were not necessarily condoning, but simply couldn't do anything about. Several states have actively addressed this issue through state constitutional amendments and legislation placing power to draw electoral districts in the hands of independent commissions by mandating particular districting criteria for the map makers or prohibiting district lines for partisan advantage. Congress also has the power to do something about partisan gerrymandering based on the Constitution's election clause, but the congressional legislation to fix partisan gerrymandering with federal standards is stalled in the Congress. In her dissent, Justice Kagan said, and I'm going to basically quote here, in our government, all political power flows from the people. And that means, as Alexander Hamilton once said, that the people should choose whom they please to govern them. But in Maryland and North Carolina, they cannot do so. In Maryland, election in and election out, there are 7 Democrats and 1 Republican in the congressional delegation, while in North Carolina, however the winds blow there are 10 Republicans and 3 Democrats. Is it conceivable that someday voters will be able to break out of that prefabricated box? Sure. But everything possible has been done to make that hard. to create a world in which power does not flow from the people because they do not choose their governors. Of all times to abandon this court's duty to declare the law, this was not the time. The practices alleged in these cases imperil our system of government. Next case from 2023, also from North Carolina, was Moore versus Harper. And in that case, last June, the court ruled 6-3 against North Carolina Republicans after voters challenged gerrymandered congressional maps drawn by the Republican-controlled state legislature in 2021. The North Carolina Supreme Court ruled that the maps were created for unfair partisan advantage and violated the state's constitution. In this case, the Supreme Court's decision rejected a broad interpretation of what's known as the independent state legislature theory, ISL. The ISL theory maintains that only the state legislature has the power to set rules for state laws that apply to federal elections, including the drawing of congressional district boundaries. The Supreme Court held that the Elections Clause does not give state legislatures exclusive authority to set rules for federal elections. This means basically that state courts retain the authority to apply state constitutional restraints when legislatures act under the power conferred upon them by the Elections Clause of the U.S. Constitution. Some believe that this decision struck down the independent state legislature theory, but there's some debate over language related to the role of federal courts in election disputes. This comes from a concurring opinion by Justice Kavanaugh, where my sense of it is that the federal courts can restrain state courts' review if state courts create their own law, new law that didn't come from the legislatures. This is still an untested concept. Also in 2023, but this time coming out of Alabama, regarding the Voting Rights Act, case of Allen versus Milligan, the court held that Alabama's 2021 drawn congressional map violated the Voting Rights Act of 1965. The plaintiffs included a number of Black organizations and voters. They filed their complaint in 2021, claiming that the state's new congressional map was racially gerrymandered. The plaintiffs sued in federal court to require Alabama to draw a second majority Black congressional district as required by Section 2 of the Voting Rights Act and as found by a federal district court in Alabama. So last June, the Supreme Court ruled 5-4 in favor of Black voters, affirming that the trial court's ruling struck down the map and required a new map. Many considered this ruling a watershed moment for the Voting Rights Act because the court essentially reaffirmed the staying power of Section 2 of the VRA. And interestingly, after this decision came down, the state legislature basically refused to draw a map, rebuffed the federal courts, and the federal courts stepped in and took control of the mapping process itself. The next case, which is still really an ongoing matter, is the Arkansas NAACP versus the Arkansas Board of Apportionment. This is a pending lawsuit challenging Arkansas State House map for violating Section 2 of the Voting Rights Act by undermining the strength of Black Arkansans, pardon me. The lawsuit was filed on behalf of Black voters whose political power was severely diminished by the current State House map. According to the lawsuit, the 2021 map produced by the Arkansas Board of Apportionment had the effect of diluting the voting strength of Black voters across the state. The Board of Apportionment should have drawn at least 4 additional Black majority districts to reflect the state's growing Black population, according to the plaintiffs. And after a week-long trial in Arkansas, and despite acknowledging that the Voting Rights Act groups had demonstrated that they did have a strong case that the map violated the VRA, a district court in Arkansas ruled that the groups, in a very radical decision, the court concluded that impacted voters could not sue under Section 2 of the VRA, that only the United States Attorney General was empowered by the language of the Voting Rights Act to do that. This unprecedented decision was appealed, but in a split decision with the chief judge dissenting, a 3-judge panel of the 8th Circuit Court of Appeals affirmed the district court's ruling. Now, for over half a century, private individuals have brought cases under Section 2 of the VRA to protect their right to vote. More than 400 Section 2 cases have been litigated in federal courts, with the vast majority brought by private plaintiffs, including at least 12 cases before the U.S. Supreme Court, including the Allen versus Milligan case from Alabama last year. No court has ever denied private actors' ability to bring their claims in federal court, with the sole exception of the courts in this case, threatening what is left of the Voting Rights Act. Last December, a petition was filed for a rehearing of this case by the Court of Appeals to rectify its decision and reaffirm the private right to enforce Section 2 actions, but the Eighth Circuit denied the petition for an en banc hearing, and the petitioners have about 1 month left to decide whether to file a writ of certiorari before the U.S. Supreme Court. This case is still pending and could have major national ramifications. The last case I'll mention just happened yesterday, Portugal versus Franklin County, Washington. And in that case, private individuals challenged the Washington State Voting Rights Act from its constitutionality. Essentially, Washington State, like New York State now, has a state voting rights act that requires such actions as pre-clearance by local governments for with histories of past voter discrimination from letting their laws go into effect without pre-clearance. Also provides for a private right of action to challenge local government structures and election laws. And yesterday, that case where the lower courts upheld the Washington State law, the Supreme Court denied cert. 4 justices, they didn't have 4 justices to support the challenge. So the Washington State case, the state law stands. Now in New York, we have a new Voting Rights Act, and there have been 4 or 5 actions brought under that law. 2 of them now, one in Nassau County and one in Westchester County, are both being challenged as unconstitutional in state court. So the likelihood of those cases going to the U.S. Supreme Court, should they go that route, are much less likely at this point. So yesterday's news from Washington State was a good omen for New York State. And with that, covering the last 10 years at the Supreme Court, I'll call it a wrap. And thank you very much.
Thank you, Jeff. And what a great summary of what has happened over the last decade or so at the federal court level, the tremendous impact these decisions have had on redistricting. Now we hear from Esmeralda Simmons, and she is going to bring us up to date on where things stand in the state of New York. So Esmeralda, you're on board.
Esmeralda, you are muted.
Yeah.
Thank you, Richard. Thank you, Jeff. It was a pleasure to be here, but I have to talk fast because there's a lot to talk about. First, I want to tell you that this is a saga. This round of redistricting is truly a saga, and for me to capture it all, we have to go all the way back to 2014, when there was a referendum to change how New York State redistricts, which created the Independent State Redistricting Commission. That was created through referendum, and the referendum was a signature piece of former Governor Andrew Cuomo's promise to take the politics out of redistricting in New York State. That promise came to fruition by creating this 5-5, or I should say 4-4-2-2 commission, 4 Republicans, 4 Democrats, and 2 independents. An even numbered commission, if you've ever heard of such a thing, that was supposed to make a decision on whether or not to, on how New York New York redistricting was going to occur. It also had the NOMA of being independent, even though the appointments were being made by the state legislature with two independent, I should say, two persons who are not registered in any party being added by the commission members that were appointed by the legislature. Now, to say that this turned out to be a disaster is be mild. Very costly disaster. I don't know. I don't know how many of you follow government, but an even numbered commission is a very rare thing, particularly when you have something like redistricting that will demand that there be a majority and a minority in order to get the plan passed. Needless to say, it wasn't even a month before the commission broke down into pure partisan lines, with the two independents going, one with Republicans and one with the Democrats. They were unable, when they were supposed to, when they were required to submit to the public and to the legislature an insight into where they were going by submitting one plan. They did not do so. Instead, they submitted two plans to the legislature. And when the time came for them to submit one plan so that the legislature could take action and either vote it up or leave it alone or vote it down, they did not submit at all. Instead, they sent a letter to the legislature saying that they were unable to come up with a plan, and then quietly retreated to the background. This did not bode well for the plan that they submitted. The legislature quickly passed its own plan. Very, very quickly passed its own plan. And rather than adhering to the mandates of the Constitution, the administrative mandates of the Constitution, within days, the legislature passed a plan that was very favorable to Democratic Party candidates. I shouldn't say candidates, to the Democratic Party. And almost immediately thereafter, there was a lawsuit brought Hockenreiter in the 3rd district, challenging the plan, and challenging the plan as being overly partisan, as a Democratic gerrymander. I'm going to speed up because I'm running out of time already. Let's put it to be quite clear. There was a special master appointed by the judge in the Hockenreiter case. The special master drew up a plan, and notwithstanding that plan was the plan that was used in the 2022 elections, state elections and constitutional elections. And everyone thought things were over until there was another case brought, Hoffman, in the first, excuse me, in the first department. So in the Hoffman case, challenged the entire redistricting process and said that the state legislature had not followed the appropriate administrative rules under the Constitution, and that the case should be brought back to the state court. This was in the 1st district in Manhattan, and that there should be a new plan drawn up by the independent commission, and that new plan should go through the entire process as mandated by the Constitution. Well, the Court of Appeals on this decision agreed with the lower court decision, agreed with the plaintiffs, and sent the case back, sent the entire redistricting back to the districting commission for them to draw up a new plan. Most of us threw up our hands in that at this point because we didn't think that was possible. But lo and behold, they were able to draw up a plan that they had a majority vote on. As a matter of fact, they only had one dissent, and I'm talking about the districting commission. And thereafter, the legislature, following the process correctly this time, gave rise to a new plan, and then sent that plan up to the governor. And that plan was adopted, was signed into a law by the governor just recently, February 28th of this year. And that ends the saga of this time around of New York State redistricting. What we need to understand, however, is that this may be a one-chapter saga, because everybody agrees that the constitutional amendment that created the Independent Districting Commission is woefully flawed and will only result in further litigation. And there are people at right as we speak, some members on this panel that are arduously working to create a new referendum so that we can have a commission that will operate correctly. I'm now turned to the next big undertaking that's occurred in New York State. New York State is now the second state in the country to, I might be wrong about second. California was the first. New York State now has a New York State Voting Rights Act that went into effect just this year. And as you've already heard, there's already litigation pending, one in Nassau County and one in Newburgh, under the New York State Voting Rights Act. And it also claims by some counties that they should not be covered by this act. Orange County to be specific. Finally, a note that for the first time since the 1990s, since the creation of the New York City Districting Commission, there is a legal challenge to the Districting Commission's map. And that challenge is going on in the first department. It's being brought on under the theory that is DC's rises versus the commission, under the theory that in fact the commission did not adhere to its standards to protect minority voters, in this case Asian voters in Queens, and did not in fact protect them at all, and in fact ignored them as a community of interest and as a protected class. We'll see where that goes. At this point, it's already moved to the, it's moving along, and hopefully we'll have a decision on that before the end of this year. I want to say that there probably will be more New York State Voting Rights Act litigation, which promises to make New York State only second to Texas in having litigation go on for an entire decade, even as we move into the new census. I might have left something out, but those are the big hits. I do hope that you follow what the major flaws were with Hockenreiter and Hoffman. That as usual, procedure will trump politics. And I'll pass it on now.
Okay.
Thank you.
Thank you, Esmeralda. And we now, I think, have a solid understanding of what has happened with regard to the scope of federal court review, which is significantly narrowed, what has happened in the state, as described by Esmeralda, and how the 2014 amendments just have not worked. And therefore, the question for us as we approach 2030, which after all is not that far away, is what do we do? How do we make all of this work? And for that, I'd like to hear the thoughts of Susan Lerner.
Thank you so much. I am very pleased to be part of this distinguished panel and impressed with how both Jeff and Esmeralda were able to get through a huge amount of information, because we are unfortunately, as Esmeralda pointed out, in continual litigation mode on redistricting. And so I want to talk about different models which exist and the challenge that we have in New York in reforming our redistricting process. First of all, I would like to caution, and I think when you hear the long shaggy dog story of what happened after the 2014 amendment, that you should not give much credence to whatever name is given to the redistricting process, right? We've got a independent redistricting commission set up by our state constitution that has been anything but. And I will note that we at Common Cause did receive a court order in 2014 preventing the commission from being described as independent on the ballot referendum because it so clearly is not. And we see this across the country, unfortunately. Commissions, there is a move towards appointing commissions rather than having the legislature draw their own lines, at least in some states. But we see a wide variety of processes to appoint those commissions that range from the situation we have in New York, a commission which is independent in name only, to truly independent commissions, of which the good examples are California and Austin, and actually here in Syracuse in New York. And those are commissions where there is an open application process, and the commission is initially chosen by lot, basically drawing randomly out of a pool of qualified applicants. And then those qualified applicants, half of the commission drawn by lot, are then charged with filling out the rest of the commission to have the commission be more reflective of the geography and the ethnicity of the particular jurisdiction. That works very well in California. It's worked well in Austin. It worked very well in Syracuse. But Syracuse is the real exception because in Austin and in California, with a somewhat similar system in Michigan, those systems were adopted through referendum, not through referenda, but through initiatives, where citizens are able to petition to put an ambitious plan on the ballot. We do not have that ability here in New York. And what was singular about the Syracuse system is that the Common Council in Syracuse was willing to place a referendum on the ballot and allow the voters to actually adopt an independent process. But even in Syracuse, we had to compromise a bit to get it on the ballot, because in California and in Austin and in Michigan, once the commission finishes its work, the plan goes into effect. There is no veto on the part of the legislature. In Syracuse, we had to convince the Common Council, to its credit, to adopt the commission's map, and they did. Ideally, a truly independent commission has its map go into effect without any possible legislative veto. There are various different ways in which a commission can be put together that gives the legislature more of a role, but not a dominant role. Or interposes another entity to do the selection process. So for instance, in Colorado, they rely upon retired judges to choose their commission, and the map is ultimately approved or disapproved by their Supreme Court.
Excuse me.
And we have a recent proposal just introduced in the last week in Pennsylvania, where again, they do not have an initiative process. So any redistricting reform has to go through their state legislature. And there, what they are proposing is that the commission would be chosen by their ethics commission. Again, to have some independence, and it would be basically a portion of the commission chosen by the Ethics Commission through an open application process, and a separate portion, but not a majority, chosen directly by the legislature. So that's an interesting compromise between a truly independent appointment process and one that does give the legislature some role. So we're looking at the full span of these options to see what we think will work adequately in New York and that we can get through our state legislature.
Great. Excuse me, Susan. I am going to interrupt to share our code word for those of you who are seeking CLE credit, this is the one and only code word that you need to record on your forms. You should have received your affidavit of attendance via email. So your CLE code word is vote, which you will see on your screen. It's spelled VOTE, as in we encourage people to vote in elections. Again, that is your first and only code word for this program. Thank you.
Okay. Jeff or Esmeralda, do you want to comment on what Susan has presented?
Esmeralda, do you want to go first?
You're on mute.
You're on mute,
Go first, Jeff. Go first.
Oh, okay.
Okay, well,
Jeff, you're up.
Susan presented an excellent overview of a lot of the options that we could consider in New York, but we have to look essentially at reforming the process. We can't let the Rube Goldberg type bells and whistles appointment process and commission process and legislative approval process play out the same way as the 2014 amendment. We've got to make this more normal and also subject the enactment of a plan based on majority votes and not a convoluted process where whether there's divided power or one-party power, different rules apply. We also need to look at the criteria, the rules, compactness, contiguity, population equality, minority voting rights, partisan gerrymandering bans, community of interest, and prioritize those in a ranked order so that there's some sanity to the process, that if you can reach higher criteria, then lesser ones might not matter as much, but at least you can defend a plan and not be stuck with a million choices, not be able to get to any conclusion. I worked in Syracuse as the advisor to the commission there and just watched how an independent process could play out. My only criticism of Syracuse was that the final vote was still left with the Common Council, but we got that through. And it was a very unique experience to work in a non-politicized atmosphere in New York. So process, rules, and the way the courts deal with redistricting all need to be addressed through a new amendment, and also to find a common ground to get something through the legislature, because we haven't seen it yet, but someone's going to come up and say the process worked just as we expected it to. And we have to be
Yes,
able to
that was the
overcome
problem. It worked just as we predicted it would.
Right. Okay.
So I am going to pipe in here. I just wanted to remind everyone that we're still under that 2014 constitutional referendum. We have less than a decade to change what we need to change to get independent commission, or get a commission that can work together, constructed. And I also want to mention the fact that in 2019 and 2020, the state legislature tried to change the state constitution in regard to redistricting. Had some, in my opinion, some good revisions, not enough, but some good revisions, and that when it went to referendum, it failed.
Yeah.
So there's much more to this, folks, than simply having a good plan, whether you thought that the legislature's revisions were good or not. The question is, not only do you have to have a good plan, we have to get this past a referendum. And in New York, that even with the parties in the party quote being in favor of it, that was a Democratic referendum. It didn't pass. So the question is, how are we going to not only come up with something that's workable and recognizes the people as the true voice that needs to be heard, but also how are we going to get it passed under the current state constitution for referendum?
Well, first of all, I think the real failing in the 2019-2020 effort to revise the Constitution was that there was no coalition. There was no real push. The legislature put it on the ballot and walked away. So, there is a coalition which is forming. for fair and independent redistricting in any state where we have successfully changed the process. We have done it through political organizing, and that's going to be essential. We're going to have to convince the legislature with enough broad support that there is a better solution. And then we're going to need a real campaign to pass it.
Yep, the legislature, as Susan said, passed the amendment in 2019 or 20, but then just walked away from it and
Yeah.
assumed that it had such good ideas in it that weren't
Yeah.
just redistricting, but ballot access, all sorts of things that at the late in the process, in October, dark money appeared to wage a major
campaign against it.
Yes, and the pro
And-
side had not even six
Right.
figures to support it.
Yeah, and the Democrats were warned, you've got to get your act together, you've got to do something, but that fell on deaf ears.
So it has to come from
Let me
us.
ask you, this raises an interesting question. Given the difficulties of enacting a constitutional amendment, should we now revise the 2014 amendments and adopt something new in the Constitution? Or are we better off repealing them and hope that the legislature can adopt something so that if there's fault, we don't have to go through the constitutional process again?
Well, whatever we do, if you read the 2014 revised Constitution, you're going to find language in there from 1894,
Yeah.
from 1938. There's so much junk they left
Scandalous.
in there that the U.S. Supreme Court has overruled. It says that every county shall have an assembly district. That was outlawed by the Supreme Court, Baker v. Carr, 1962. The best thing would be to incorporate new language, easy to read, plain English that people can follow. I challenge the 190 people on this call to go back and read the amendment and see if, aside from the headache you'll get, to try to make some sense of it. Good luck.
That in and of
Well,
itself
actually,
is
it's
a
a
red
comedy, so
flag.
it makes you laugh, believe me.
It was a
It
red
does.
flag that they were not serious about really having an independent process, because they did not clean up all of the unconstitutional language in order to be able to pull things out of it. But that's a whole other story. The question is, what can we do going forward? And I think the only thing that works is that there has to be a strong movement towards a reform. Simply taking the bad stuff out of the Constitution and hoping that the legislature will somehow or other come up with a better system that they can then modify. I really understand, Richard, the difficulties of constantly amending the Constitution, but we have no choice. As Jeff points out, we've got to get the unconstitutional stuff out. We've got to get this pea-brained, crazy Rube Goldberg system out. I totally agree with Jeff that we need to prioritize our criteria, because that has a really significant impact on the final map. And we're just going to have to put our shoulders to the wheel and build the political strength to demand and institute at least a sensible system, if not one that is the ideally independent one that we would get if we could go directly to the voters.
I'll also add that, as most of you know, most of the challenges in the last 3 decades you've all been around have been on the basis of discrimination against minority voters for the most part. And now with the New York State Voting Rights Act, it's going to be front and center regarding redistricting. But as you both noted, that was not front and center in the 2014 changes. Not only does it have to be front and center as we walk into the revisions, but I dare say that even the 2014 revisions, as they were applied, could arguably stand to be challenged even under Section 2 of the Voting Rights Act, because of what it has resulted in the prior cases before. I'm talking about in the first renditions. So I'll put it like this: we have a tremendous amount of work to get done, and coalition building is the only way to go about it. The coalition has to be very, very broad. We want to go beyond the very principled and mighty Association of the Bar in terms of recommendations, and bring it to the local level. And we will have to involve, the local clubs and local elected officials who are prone to be against anything that even smells of change. That includes legislators of color as well. So I guess my only concern is that we have so little time and so much to do. And as of yet, we have not agreed on what our major push is going to be. And I thank you, Susan, very much for all the work you've been doing. And I know, Jeff, you've been on the battlefield as well. But there's much more work to be done than the two of you can do. So folks who are on this call, you not only have to vote, but you have to get behind more than an idea. You really have to get behind a constitutional amendment.
So if we did a constitutional amendment, do you believe the legislature should be totally removed from the process? Or do you believe that there should be some role left for the legislature?
Are we talking
Totally removed. Totally removed.
in an ideal world? Totally removed. Let's start with what we want, and then we'll negotiate what we can get.
Or I'll put it like this: try what they do in New York City. The legislature has the ability to comment on the plan, and then it goes back to the commission, and the commission does what they want with those comments, and that's it. But the last voice, the last person to sing has to be the commission. Otherwise, why even have it?
Let me just add.
But let me just add. So you're saying you would allow legislative comments as long as the commission makes the final decision?
Yes.
Correct.
Yeah, the New York City Charter allows the council membership to review and suggest amendments to a commission-drawn plan. But after those comments are received, then the commission itself draws the final plan. And as long as it receives a certain number of votes, 9 votes amongst the, I think it's 9 votes amongst the members of the commission, or 13 votes, then if it's certified and goes straight to the city clerk and it bypasses the city council. But let me just mention in terms of the New York legislature, the state court map for the congressional districts drawn in 2022 that was vilified, 95% of that map was used in the map that the commission sent to the legislature. Now, when the legislature changed the commission's map, they only changed about 5% of that map. So in essence, the map that New Yorkers now have as a legislatively enacted congressional map contains about 90% of what a court-drawn map included, and that was not drawn by the legislature. So what's the big fear? And if they do change things, it's going to be bound to be for incumbent addresses, making sure certain members are located in their districts, the very things the 2014 amendment was designed to avoid.
Yeah.
So take that.
So would you allow the courts to continue to play some role here, possibly by appointing a special master in certain circumstances?
Well,
Sort of as an insurance policy, if you will.
New York has had
I
special.
think the courts are always an
Esmeralda.
insurance policy. You could always litigate. I don't think you have to mandate that the courts are involved before somebody decides to challenge a plan. I think the courts know what to do once there's a challenge.
Yeah,
I think they should be left out of it.
I think we've learned, I think I disagree slightly that if the courts should, there's a role for the courts to play if the legislature fails to do their job. And that's what happened in New York in the 80s when there was a stalemate. A special master was appointed, but the legislature finally came through and agreed on a plan. Same thing happened in 2002. Legislature couldn't agree on a congressional plan, but then the master was appointed. Then the legislature came through at the 11th hour. But in 2011, the legislature did not agree on a congressional plan. There was no plan in place, so the courts had to step in to appoint a special master.
So,
as I said, the courts
in
have
the
been quite
end,
involved.
what you're saying is, in the end, whatever procedure we adopt does not result in lawful maps. There are still the courts to be available to
Well,
appoint a special master.
We don't want an independent state legislature theory to, emanate out of New York. Put it that way.
That's for sure.
So now, how do you create an independent commission? And I know Susan talked a little bit about this, but how do you think we can best create an independent commission?
Well, in an ideal world, we would follow the California model. But as I said, what we're seeing across the country is different variations that run from, a completely independent California system to, an allegedly independent system appointed by the legislature. We have to get the legislature out of this process. One thing that's perfectly
When you say out
clear-
of the process, you mean the appointed process.
the appointed process and the approval
And
process.
removal.
Because the one thing that is extremely popular, if you go to the public and you say, should the legislature be able to draw its own district lines? What we hear over and over again across the political spectrum is voters, not politicians, that voters should choose politicians. Politicians should not be choosing their voters. And that's the system we have right now in New York and many other places where the legislature has a stranglehold on gerrymandering.
And the tough nut to crack in New York is going to be what entity would vet the commission, would set it up, how would it be done? Syracuse has a publicly elected auditor,
Right.
but an auditor can be given ministerial functions that are delineated in law so that politics can play a part. In other words, do 1, 2, 3, 4. There's no discretion. Just do these ministerial acts, and that's where things like lotteries come in effectively, where there's no subjectivity. It's simply done on an objective basis. We have that's going to be a big nut to crack in New York as to who would administer the commission. With our current commission, we saw they created a commission where the legislature, the state shall fund it. What happens? The last governor comes in and tries to control the budget with his own appointees. It delayed things for a year or two. It was ridiculous.
So there are different, we have a lot of proposals and experience across the country to pull on with a lot of good ideas. There are a lot of people who are looking at exactly these issues. And I think that we would be able to craft something which would be sufficiently independent and workable for New York. This is, yes, it's complex. There are a lot of moving pieces, but there are a lot of good ideas and a lot of practical experience.
I am not as confident as my colleagues are. I'm not opposed, but I am not as confident as they are about how this will actually go into effect if without some concession to the sitting legislature and the governor. Not that they should have final say, but to think that they will actually support, I think they will vigorously oppose, and then they'll try to get the parties to vigorously oppose. Do we have enough people power to get past both parties? I don't know about that.
Well, I'll differ a little bit there. From a bargaining point of view, you don't want to come to the table with half a loaf. And when Susan talks about coming to the table with complete independence, then you can start negotiating from your point of strength, not giving them half a loaf at the front end.
Oh, I'm not disagreeing with that at all.
Okay. I think we're all in agreement at the
Yeah,
right now.
absolutely. But are we?
I'm looking at after we put that
Yes,
forward.
but that's
how are we going to get these folks to either say, okay, let's do it, this is fair, and to say we're willing to put our quote unquote power aside and let a fair process take place if and only if the criteria is very, very blatant about how it protects voters.
Let me throw one thing on the table.
Can I just say we're running out of time? We're getting near the end of our period. But I would just like to ask you, it is now, we're now in 2024. If we do a constitutional amendment, it has to be drafted. It has to be passed by 2 sessions of the legislature and then submitted to the voters for their approval. Can
Exactly.
it be done in time?
Yes.
So there are some very interesting questions which are in the Q&A. And I don't know if we have time to address them, but I did want to point out, there was a question,
Yes.
what's the California system? The California system is an open application process where a pool is created of individuals who have the necessary analytical skills and a nonpartisan outlook to be on the commission. Half the commission is chosen randomly, and then that half chooses the remaining half to reflect the diversity of the state. There's a question, shouldn't anti-gerrymandering be established nationwide? Yes, absolutely. And there is a bill in Congress that would do that, but are you going to put any money on the table as to its likelihood of passage in a dysfunctional Congress? Hopefully down the road, when we have a more progressive and functional Congress, that's something that we could get. And then the last question, somebody else want to take this from Charles Sullivan, since I've been
Sure.
yakking away?
What
I
is
can
the
read
last
this.
question?
I'll read it out. Why is the legislature in New York, a very political body, allowed to have a role at all in mapping the districts?
Well, state
and I guess this was a history kind of
Yeah,
question.
that's a history lesson.
Look, State, Esmeralda, go ahead.
Because the original, not even the original framers of the New York State Constitution, let's say the framers of the current New York State Constitution thought that elected representatives would be a good place to start in order to fulfill the will of the people. That is a very good rhetorically. That's not the way it works out.
Yeah, legislators can actually craft a decent plan. Massachusetts has done it for 3 decades straight, but once legislators get greedy, they overreach, they do self-serving acts. That's when they go too far and get slapped by the courts or the voters and have this taken away from them. I'll just have one closing comment. I work in and around the legislature now for nearly 50 years. Started with Stanley Steingart as Speaker in the 1970s, and I've seen this legislature change. There is more turnover now. There are more newer members. There are more older members that are retiring now that we might start seeing, maybe not in the immediate future, but a much more independently minded legislature that just won't be under the strict control of their chamber leaders. Maybe I'm wrong, but I've been around long enough to see big changes happening in the last few years.
Well, I see it is now 1 o'clock, so our time is up, and I can't thank the panelists enough for both an educational and a fascinating discussion.
And I echo those sentiments and thank all of our attendees for your participation as well.
Thank you.
Thank you very
Thank
much
you.
for having me.
Thank you all. As
Thank
a
you all.
reminder, for those of you seeking CLE credit, please email your CLE forms to Lisa Rivage. You will get another email from me shortly with those forms. Thank you.
Thank you all.
So long.
Good afternoon.